Hi everyone, and thank you so much for joining us today. In today's webinar, we have a very special guest, Mehak Khanna, who is going to talk to us about India's latest Digital Personal Data Protection Act. Most of us in this industry, in the OTT industry, collect data from our users. We've faced a lot of problems while trying to sell in other countries like the European Union, California, in the United States, in Brazil, all of whom have their own data protection laws. So these laws are super stringent. They govern what you can collect, what form you have to store the data in, how you have to store the data, for how long, consents, withdrawal of consent, and it's quite complex. Especially teams that collect millions of records per day, you have to get it right in the first shot. Else you'll have a lot of cleanup to do. So we have Mehak here, who's an expert in data, who's going to talk to us, enlighten us about this today, and also take audience questions. Here's something about Mehak. Mehak is a seasoned corporate lawyer with over 15 years of experience, both in law firms and in-house legal experience. She has led a lot of strategic deals for large conventional companies like Airtel in the past. That's how we know each other. And also for new age, fast growing tech companies and also investors. Right? She has overseen intricate restructuring, merger and acquisition transactions, orchestrating contract drafting, negotiations, all the complex stuff that you and I probably don't want to touch. Best left to the lawyers in the room. A lot of international experience, as you can see, working with across deals and negotiations in Sri Lanka, Pakistan, the Middle East, United States, Turkey, European Union, Southeast Asia. She also won a lot of awards. She's a recipient of the prestigious awards like the ET Prime Women Leadership Award in 2021, Asian Legal Business India Rising Star 2021, Forbes 40 under 40 Top General Counsel 2020, and 40 under 40 Rising Star Award by the Legal Era 2020. So with this introduction, let me just hand it over to Mehak. A quick introduction by yourself again, Mehak. And also let me pose the first question. What is DPDP and how scared should we all be?
And thank you so much, Krishna, for the wonderful introduction. And thank you for having me here and for all those gracious words. So yes, what is DPDP and should companies and organizations be scared? So DPDP is not defined under the law, but as we know, it's the Digital Personal Data Protection Act. And this particular law deals with protecting the personal data of individuals, and personal data is something which is defined. So any data which helps us identify an individual is the personal data.
Okay.
And coming on to your second part of the question, should companies be scared? I don't think they need to be scared, but they definitely need to pull up their socks.
Okay.
They need to, set the ground running,
Okay.
and they need to prepare. That is something they definitely need to do.
Perfect. Okay, so let's start. I have a bunch of questions to ask you.
Sure.
We've got a couple of audience questions as well.
Sure.
So just a quick reminder to our audience, you're muted. You can't switch on your cameras. So please use the chat box to pose your questions. I'll pass it on to Mehak. So Mehak, you have defined DPDP to us. First question, right? So I am bringing all of these questions from an OTT and OTT perspective.
Sure.
And when we talk about OTT, there are two angles to this, right?
Mhm.
I'm either a service provider like Z or Sony.
Yes.
So, provider to these OTTs, I might be a data analytics provider. I might be a vendor who specializes in subscriptions. I might be a vendor who specializes in ads. So I go and sell a Z and Sony, right? So there are many companies like this in the OTT space who hyper specialize in audience analytics, subscriber churn analytics. And often I've seen that the buck gets passed, right? OTT says, hey, I'm using XYZ vendor. That's his problem. And the vendor says, it's their app. They should be asking permission, not me. So all of these questions that I'm going to pose to you today are coming from that perspective. Okay.
Sure.
So first of all, when we
Hmm.
talk about the GDPR, one of the murkiest problems is it says for you EU citizens. So let's
Yes,
bring that question here, right?
yes.
Does VPDP apply only to Indian citizens in India, or
Yes.
Indian citizens living in Singapore, or foreigners living in India? Can you explain this to us?
So in terms of, the applicability of the act, so
Hmm.
the act, of course, it is, just to say that the act is in force currently. I just want to clarify that because the government has mentioned that certain clauses of the act are going to come in force when they notify it.
Okay.
So just wanted to put that disclaimer up front that while the law is in place, this is the law, it's been notified in the official gazette, but there are going to be certain provisions, especially those pertaining to setting up of the board, the data protection board, which is, going to come in future. And yes, absolutely understand where you're coming from in terms of, who this applies to.
Yeah.
So yes, in terms of the applicability, it applies to any individual within the territory of India.
Okay.
So if you see, it does not, it does not specify applicability based on citizenship. But what it says is that any individual who
Mhm.
is based out within the territory of India
Yeah.
and their data is saved in digital form,
Okay.
or it is saved in non-digital form but digitized subsequently.
Okay.
So all of such individuals are going to be covered.
Got it. Within the territory
Yes.
of India. So
Within
it.
the territory of India, yes. What
Okay.
is not covered is it doesn't apply to individuals whose data is, not in digitized form. It doesn't apply to individuals whose data is, being used for a domestic purpose, which is a non-commercial purpose.
Mhm.
It doesn't even apply to data which is publicly available.
Okay.
So this law doesn't apply to all of these categories.
So to just clarify it for my own understanding,
Yes.
I I am a subscriber, let's say, of Sony Live.
Yes.
So Sony Live is bound by the DPDP Act. I'm living in
Yes.
Bangalore. I access the service here. When I
Yes.
go to Singapore, does it still apply to me?
If your data, I mean, you can travel to Singapore, but if, I mean, you're somehow, I don't know if you mean to say that for a limited period you travel to
Yeah.
Singapore,
Yeah.
then that's not going to impact because you're essentially doing, business or your commercial activities are taking place in India. And for that purpose, Sony or XYZ company has stored your data.
Got
So
it.
for all practical purposes, you are within the, territorial domain of India.
Interesting. Interesting. Because
Yeah.
this will impact a lot of OTTs who actually run their business from India, but
Yeah.
send subscriptions across the world. Uh,
Yes, and also this is going to impact the OTTs as well as the service providers because the problem that you spoke about is a very realistic problem where, organizations say that, I mean, their question is, are they responsible? And they want to put the obligation on the vendor, and the vendor wants to put that obligation back
oh,
onto the organization,
yeah.
which, OTT in your case.
Yeah.
However, the law has come up with two concepts, the concept of a data processor and the concept of a data fiduciary. So
Okay.
the data fiduciary is an organization like an OTT that decides how the data is to be taken, processed, and stored.
Okay.
And whoever they are giving this instruction to for processing the data, which is their vendors, they are the data processors. So this law creates liability and obligations for both of these classes of organizations. And hence, a lot of it is coming out of the law. What they can now do is amongst themselves have a contract where they can contractually, decide how to pick up the monetary liabilities. But as far as the legal obligations are concerned, the law has captured both of these categories of people
That's
and
interesting.
organizations.
That's
Yeah.
very interesting, actually.
Yeah.
Cool. So let me ask. Okay, so I think we probably took a dive into the deep end. Now let's just come back a bit. I'm starting a business. I'm an OTT. I have to collect viewership data. I
Yes.
have to know what people are watching, when they're watching, because that's the only way I can recommend movies to them.
Yes.
I
Yes.
have to collect subscription data. I
Yes.
probably store their credit card details, UPI details.
Yes. Yes.
I
Yes.
will store their phone number because I
Yes.
need to send them
Yes.
push notifications.
Yes.
Latest movie released, I need
Yes.
to send that, right?
Yes.
And to know where they're watching a movie from, I will collect their IP address.
Yes.
So let's bring this back. So what is the first step I should do as a business to be compliant? Is there a checklist from the government? Is there a consent form that is there in the public domain that I can use? Can you help us through that?
Yes. So, I mean, two things here. Firstly, as a business who's collecting and storing all of this data, you can continue doing that. But what you need to ensure is firstly that you are taking complete non-ambiguous and, unqualified consent. Because what normally businesses do is the consent that they take from people is quite ambiguous, saying that, we are going to collect XYZ of your data and we may use it for ABC purposes. And those purposes are not well spelled out. So first thing is unambiguous and clear consent. The second thing is to have it, comprehensively laid out in the form of the user terms and conditions or the privacy policy, so that the user is well aware. And thirdly, it is important to use that data only for a legitimate purpose, for a lawful purpose, and only for the time period for which it is necessary. And because it is important that that the data is something which is used for the disclosed purpose and used for the disclosed time period. Because if that doesn't happen, then you'll have to again go back to the user and take an updated consent for all the additional categories and the additional time period for which you are storing the data.
Very interesting.
Yeah.
Interesting. So again, on that same point, let me ask you two questions. We had an audience question which came in, which said, how does a platform, a service provider who provides services across multiple devices? So this is common in OTT. I have a website, I have an iPhone app, I have an Android app, I have an Android TV app, Samsung app, multiple apps. And the peculiarity of the industry is each of them have their own ways of collecting money. Phone I have to pay through Apple Pay, Samsung has to go through Samsung Pay, Roku goes through Roku Pay. So they had a question, how do you synchronize consent forms? Is there a simple answer to this?
Because this question is asked in the context of devices, different devices, I like to answer it from, legal and a practical standpoint. What is happening is that the user is going to each device for a different app and for a different purpose. And they're making a separate payment for different set of services. Hence, all of these separate tracks are separate contracts as far as the customer is concerned. So your customer or the user is, applying for these separate services through each of the devices, which means that if the scope of the service is different, then there can't be one consent for it. Because it's a different scope, there's a separate payment being made for it. The scope of the service is totally different. The data might be the same. But then if the customer is coming onto a different device each time and putting in the data each time and making a payment each time for a different set of service, then the consent would also need to be taken of that customer or user each time.
Okay, got it. And it's actually that increases the workload of a company because...
It does because it is extremely important now for a company from an organizational, technical, and from a sanitization standpoint to check what are the various sources of data, where all do they collect the data, and where all does the data leakage happens. Because only if they check all of this are they going to be able to come up with a roadmap to deal with all of this.
Interesting. So related to consent, obviously, is consent withdrawal and data deletion. Data deletion is a very big headache, I feel, from a data perspective. I think I've faced this multiple times in the past where you're trapped in this circle of don't identify the user, but when you want to delete them, you have to accurately find them and delete all records of them. So let's tackle that one by one. First one is consent withdrawal. Are there any stipulations, anything on the app? How easy should it be? Personally, I have dealt with OTTs who try and make it very difficult to withdraw consent. Right? They hide it within 5 layers of the app. Call my call center, then they'll give you a code, then you get. Is the law trying to get rid of all of this? So,
Yes, you're right. The law is trying to get rid of all of this because this is no longer going to be a contractual right, and the users or the customers are no longer going to be dependent on the OTTs
ah,
to be able to give them this option. So the
okay,
customers and the users have the right to have their data updated, have their data deleted, have their consent withdrawn. They have all of these rights. They also have a right to nominate their legal heirs. They have a plethora of rights, and these are legal rights irrespective of whether OTT puts it in its user terms and conditions or puts it on its websites, or whether they put it on their app is immaterial. The
okay,
fact of the
okay,
matter is that the users and the customers have this right and they can exercise it. They can also exercise it by doing something as simple as writing to the OTT companies and asking them to take any of these actions. So,
okay,
this is a right that they have. The government has not stipulated any guidelines.
okay,
And they've just given these rights. So, what the government might do in future is they might come up with certain rules under this act, and those rules, as and when they come, are going to they lay out the procedure
okay,
on a lot of these aspects. And I guess we just have to wait and watch till the time those rules come out.
okay.
But as of now, this is a legal right and this can be exercised by the user irrespective of whatever the OTT platform puts on their website or not.
Very interesting. And data deletion, is there anything around that?
It's
Mehak?
it's the same position.
Okay.
Yes, they've not given any guidelines around it.
Mhm.
But considering it's a legal right, the users and the customers can ask for this as a matter of legal right. So if
Okay.
they're asking for it, they're sending an email, they're sending a grievance, then that is something that the OTT platforms would not be able to sort of avoid.
Okay. Interesting.
Yeah.
I think we'll just take an audience question at this point.
Sure.
So Om Prakash Singh has asked, "Hi, is selling of data allowed under privacy regulations, specifically under DPDP and GDPR? Also, what legal mechanism is available with an organization that wants to use the data purchased from any other organization?"
So, yes, selling of data is not allowed at all. In
Okay.
fact, that is something that the government would also not want to allow because personal data is something which is, which has a lot of sanctity, and it is something which is related to a person's personal rights. And they would not want this particular data to be sold. So yes, this act does not provide for any mechanism for sale of data. And secondly, if there is any company that wants to use such data, it needs to be seen whether that data has been purchased from the users or the customers, or that data has come through legitimate means to
Okay.
the company which is giving it to its vendors. Because if it has come through legitimate means in the course of doing business with those users and customers, and if that company is sharing it with you, subject to certain terms, disclosures, and consent of the user, then that still may be okay. But if they've purchased it through unauthorized means, and because if they've purchased the data of the user, clearly the user's consent is not going to be there, because users will not want their data to be sold. And if the consent requirement is not there, then immediately one is in violation of this law.
Okay.
So if that's the situation, then I would not advise you to go ahead with such transaction.
Got it. Okay, Gaurav has a comment in embedding. I think this is a good technical comment. Embedding SDKs in cross platforms, okay, shall enable managing consents, because all these platforms have login gateways. It's easy to manage cross-device consent managements. Companies like Diadomi, OneTrust, Concur, Transcend.io provide such tech capabilities. That's
Sure. So even if they are providing such tech capabilities, what they'll have to ensure is that this consent comes off clearly each time the customer is taking a separate service and making a separate payment. It comes up as a clear pop-up
okay.
where they can either tick or cross-mark it. It can't be a hidden consent.
Okay.
Even if it is a cross-device consent, the requirement is very clear. It has to be unambiguous, clear, and the person consenting needs to know that he's consenting. And if it is a separate service or a separate arrangement, a separate agreement altogether, then it needs to be, brought up even more clearly.
Okay. Okay, I'll come back to some of the questions I have, and then after I think 5 minutes, we'll take some of the audience questions.
Sure.
One difficult issue I think with most companies dealing with GDPR is data storage, saying that has to be stored within the EU territorial regions.
Yeah.
So, is there anything stipulated for DPDP? Specifically, where
Yes.
should data be stored?
So in terms of data storage and data transfer, the government will come up with rules.
Okay.
They've not yet, mentioned in terms of whether and how the data can go out of India. That
Okay.
I think would be more on a reciprocal basis, that they'll, probably that would depend a lot on the relationship with other countries.
Okay.
Having said that, domestically, how the storage needs to be done is something that this law doesn't deal with.
Okay.
All they're saying is you need to take consent, and you need to store it and use it for a legitimate purpose.
Okay.
If you're transferring it within the entities, again, you need to take consent for all of that, so on and so forth. So any sort of storage, usage, syncing, all of that is part of the processing exercise.
Okay.
And consent being the most important parameter.
Okay.
And yes, I think from a company standpoint, it would be important for them to take certain organizational, documentational, and technical measures to ensure that the storage is risk proof. By that, what I mean is that in case, at the first stage where they are taking consents, they need to ensure that the documentations between the data processor, the data fiduciary, the customers, all of those contracts, the user T's and C's, the privacy policies, the vendor contracts, all of that are reworked upon. Then from an organizational standpoint, they need to ensure that each department within the company, each vertical knows for what purpose they're using the data, for how much time they need to store it.
Okay.
I mean, when then usage ends, when the need ends.
Okay.
How they need to ensure that the rights of the users are protected.
Okay.
They need to have their internal SOPs. And they need to have, internal business safeguards, so on and so forth. And then again, the third part of it is the technical safeguards that need to be done. Of course, utilize methods to ensure that there is anonymization, there is proper encryption, there are firewalls, antiviruses, preventing breaches, hacks, all of that. And then I think the last bit of it is going to be the sensitization to, with the employees.
Okay.
And that there is an internal security policy.
Okay.
The chief information security officer gives proper training to employees on how to handle third-party personal data, how to have these internal grievance redressal mechanisms, and if someone is not following, then how to punish, and so on and so forth. So I think all of these aspects are extremely important because of the high level of penalties that the law provides.
Yes.
Yeah.
So I was just coming to that next. So I guess what you mentioned right now comes under the two words used by the government: reasonable safeguards, right?
Yes.
There is no definition of reasonable.
There is no definition. There is no concept, and they've left it to the companies to figure that out on their own.
Okay.
And that is why each company would soon start doing the exercise of engaging technical experts, engaging security experts, and engaging lawyers to help them through this three-pronged approach that I mentioned. To ensure that the documentation is correct, to ensure that they have organizational measures in place, they sensitize, their employees, and they have proper technical measures in place. Because if it's left onto the company, they'll have to do everything possible to ensure that, this particular data is protected. And, just coming back to the saying that in today's day and age, data is actually oil. I think it is absolutely correct because of the kind of importance given to data under this bill, and the amount of penalties that can run up to 250 crores. And once that happens, it's really going to pinch the companies. So I think they need to give it as much of importance as they give to oil and bullions, for sure.
I just hope the number of spam phone calls we get reduced after this goes into. Okay. So another interesting part of the act, which I think is contentious, and there will be a lot of hue and cry. I think there's already a lot of hue and cry in the parliament, is that the government of India can at any time ask for all of your data, and they can use it for
Yes.
That's also not mentioned. And there is a huge fine.
Yeah.
Without any political color to this, what does this really
See, the government, of course, has the right, they have a lot of rights. So, as a state instrumentality, they can use the data which is in the interest of security,
Okay.
sovereignty, and
Okay.
public order, etc., or if it is used for research, archiving, and statistical purposes.
Okay.
So, a lot of heavy words,
Yeah.
but what I mean, statistical purposes, we know if suppose it's a population survey or, the economic wing of the government is preparing some statistics that we understand they would need our data. But in the interest of sovereignty,
Yes.
public order,
Yeah.
security, how that is going to be interpreted, I think is best left to the government. We'll have to see how broad or wide or how narrow they'll interpret this to be.
Yeah.
Uh, but yes, that is an exception that they've kept for themselves.
Okay.
Secondly, this law itself gives rights to the central government to call for any sort of information and data from the data protection board as well as the data fiduciary or the intermediary.
Okay.
And that is, of course, in the exercise of their powers to ensure that the functioning of this law, happens properly. But again, even in this context, we'll have to see what all data and in what all situations,
Okay.
this happens.
Right.
Because if there's a separate authority known as a data protection board, which is doing its job, then what will be those instances where the central government will have to step in and say, oh, give me all of this data, I need to check.
Absolutely.
So that is something we'll have to again see.
It's a little murky there. Also, I think probably I should have asked this much before. Is there a deadline, or is there, so companies will obviously
Yeah.
start working on this, but by when they should implement reasonable safeguards? Is there something written?
Unfortunately, yes. As of now, there's no transitional period
Okay.
by when the companies need to do this. There is also no time period prescribed as to when the data protection board is going to be up and running and when
Okay.
the rules are going to be notified.
Got it.
Also, there is no time limit for how long after the consent the data needs to be stored for. There are other laws, which would of course need to be complied with, which is what this law also mentions, that if under a particular law there is a requirement to keep the data for a certain number of years, then one would need to do that. So if the tax law requires you to keep and store the data for a certain purpose, you'll need to do that. If the Reserve Bank of India requires you to store the data for a certain period, then you would need to do that, and so on and so forth.
That's interesting. Very interesting.
Yeah.
Actually, just a comment from my side. This is probably the simplest legal document I've ever read in my life.
This is true. You're right, because the government was very sure that they're going to prepare the law in a way that is not going to have the usual drafting format. And this is something that the minister also mentioned.
Okay.
Normally, what happens is there's a law.
Okay.
And in the law, there are sections, which
Okay.
of course this also has, but the sections are worded very differently.
Okay.
They're worded in a technical format saying you can do XYZ, however,
Yeah.
provided, subject to, you can't do ABC. So then
Yeah.
it gets confusing
Yes.
because the technical jargon and the legal
Yeah.
jargon make it confusing. But what this law does, it doesn't do any of that. There are no provisos at all. What this does is it mentions simply in sections what needs to be done, what are the rights, and it flows very logically as well.
Very true.
Of course, what that also does is it makes the law very broad
Correct.
and very wide, and it of course
Open to
puts a lot of
interpretation.
questions in the minds of people for
Absolutely.
that, which I'm sure once the data protection board is up and running and once the government has rules, there is going to be much clarity.
Yeah.
And why just for this law? I think whenever there's been a new law, it takes about 3 to 4 years to settle down. It happened with GST, it happened with the New Companies Act.
Yeah.
So I think that's the nature of any law that has a far-reaching impact, that it does take time to settle down. And the more the government is going to come out with rules and guidelines, the easier it is going to be for us to interpret it.
Very true. Very true. I think we're almost close to the end of our questions, and probably a couple of audience questions are coming. I saw one interesting point. I saw an exemption. Was it for startups, or was it size of the company for this data, or are there no exemptions at all?
See, there are no exemptions for startup right now, but what this law mentions is that the central government may come up with exemptions.
Okay.
So,
Okay.
in case the central government decides to notify and exclude startups in general or a certain category of startups,
Okay.
they will come up with something in future.
Right, because it is little tough, the overhead of all of this. But then it's a double-edged sword, right? You
It
can.
is a double-edged
Yeah.
sword, and I think the government, which it's also mentioned a lot of times, the government is facing the dilemma of balancing the interest of individuals whose data is at stake, as well as companies who are, of course, in their nascent years,
Yeah.
if they're startups, but earning their revenue out of the data of those individuals. So
Very
I
true.
think that's the balance that they would need to make, because they are cognizant of the fact that businesses need to run, and that's important for the economy, but at the same time the data principles rights also need to be protected.
True. Because size is a very difficult number, because in today's date, I think a 10% startup can
Yeah.
have billions of data points flowing in every
Again,
day.
a billion of data points. I don't know if there can be a monetary threshold
Yeah.
of the revenue or the turnover of the company to
Yeah.
see if they can afford those kind of safeguards, and they're in a position of risking a lot of data. So I think that can be probably one of the criterias to also decide. But again, I don't think there's no one criteria that the government might want to look at. There can be various such criterias as well.
I think one of the biggest bullets currently people have dodged is the storage of data. Like you mentioned, there's no stipulation it has to be within India's territorial boundary, because there are a lot of people who use servers specifically in the US East Coast or in
Mhm.
Ireland, which are very cheap, which are cheaper than the rest.
Yeah.
Um, but let's see. Let's see what happens in the future.
Yes.
I think we have a couple of questions again from Gaurav. By when do you expect the government to notify about personal data board?
Hmm.
Is data compliance responsibility of the CSO, the CTO, or the CLO? Uh,
Hmm.
I think if you can take these, we can probably. There are a couple of more questions after this as well.
Okay, so the government recently, the ministry and I think the MOS mentioned that they should come out with certain details of the data protection board composition setting up, as well as certain rules soon within this year, in the next couple of months. I am, therefore expecting that they should come up with something by the end of this year, basis the minister's statement. But again, it's a wait and watch. But they would want to move fast on this. Now that they've passed the law and the next year is election year, I
Hmm.
don't expect them to keep things half hanging.
Okay.
They would want the board to be up and running.
Okay.
That's one. Secondly, whose responsibility this is. So, of course, other than the compliance officers that the law mentions for certain categories of data fiduciaries need to be appointed, it doesn't talk about specific positions. It
Okay.
says that the data processor and the data fiduciary as organizations are responsible.
Okay.
Now, wherever it's not mandatory to have a compliance officer, it is up to the organizations to fix responsibility.
Okay.
And to my mind, it is not going to be, and it can't be, just one person being the chief information compliance officer, the CISO, or his team. I personally feel, in my experience, I've seen that in every organization, it would need to be a group of people who
Okay.
would need to be responsible, which would ideally be your CISO, your general counsel, which is the legal head, your regulatory head, and also your procurement head. Apart from your business or product head, which is, who's the person who's taking a call of running the products where such data is actually coming from. So it has to be a combination of all of these people who need to be sort of responsible of operating all of the security, technical, organizational, and business measures to ensure that the data is safe.
Got it. So also, how will digital advertisements like Google, Facebook, and other ads be disrupted over OTT and other platforms?
Uh, why would they need to be disrupted if there is consent which is taken clearly? by the OTT platforms that they are taking data for a certain purposes and they might need to share it with their vendors and advertisers, then there should be no disruption. But of course, if there is a situation where the user wants to modify the consent or withdraw the consent, and suppose they say that they withdraw the consent in entirety, then I mean that's a disruption that is going to be, of course, at the business level. But
Okay.
then that's the right that the government has given to the users to be able to withdraw their consent.
Okay.
So it is extremely important for the companies to ensure that their consent language is as clearly worded as possible and it is not broad and ambiguous.
Okay.
Because if that is the case, then it's certainly going to be an issue of who said what and who understood what. And this is going to go against the companies if there's a dispute before the data protection board.
Interesting. Yeah.
Yeah.
Very good question, actually, by Om Prakash Singh. I'll just summarize it. The
Sure.
law clearly states that the act states that the consent will be presented in very clean, clear, unambiguous English.
Yes.
But obviously, India being a country with so many languages, does that pose a problems? What happens if I take consent in some other language, or is there provision to take consent in some other language? It's a beautiful question.
It is. And, if you see, yeah, you're right. It says that it should be clear, informed, unconditional, unambiguous, and it should be free and clear. See, the thing is that, let me put it this way, that you might decide to take the consent in a vernacular language or in a local language, but it is also important to take clear, unambiguous, and affirmative consent in English because A, that's going to be the official language. B, when a dispute comes up, that's the language that the data protection board is going to decide in. And C, this is the language in which your business is being done. So, all in all, if English is your language of the contracts, if English is the language of putting across the information on the platform, if English is the language for asking for money, that English needs to be logically also the language to take the consent in, if you understand what I'm saying. So, hence, it is going to be extremely important, for the consent to be drafted properly. Also, I think very soon what is going to happen is that the consent languages would start getting disputed and tested. And in the next 5-6 years, we'll see, the data protection board and eventually the appellate body and then eventually, the higher courts holding what, according to them, is the correct language of consent.
Okay.
Yeah, because that is going to vary from business to business. It is going to vary from business to business. It is going to vary from situation to situation. For example, let's just talk about storage and transfer. The central government currently, the law says that they might restrict the transfer of personal data to a country or a territory as they may notify. Right now, they've not notified. Let's say they notify, certain storage requirements or transfer requirements and they put certain restriction on countries. And if, it's a multinational corporation, that has a lot of subsidiaries, affiliates, and group companies in various jurisdictions, including the ones that the central government has prohibited data transfer to, then the consent language would need to be very carefully worded to ensure that the company, which is a multinational corporation, does not, fall foul of this particular requirement. And hence, how the consent should be and what should be the template, what should be the format is very, very subjective and it depends upon situation to situation and business to business.
It's what you just said translated in my mind as an engineer and a product manager to a nightmarish situation where I have to say this user consented to consent form version 3.
Yes. Also, Krishna, I mean, just think about, for argument's sake, digital lending apps, or the fintech apps. They need to comply with the Reserve Bank of India directions that are already very stringent. Then they'll have to comply with this law. And suppose they have 2-3 categories of fintech products. They have payment aggregated products, they have a digital lending app, and they have, 2, 3 other products. They'll have to clearly
Okay.
sit and amend their contracts and their consents for each type of product to see what type of consent is relevant in what situation for what product. So it is, of course, going to be a nightmare. And I just took an example of, fintech companies. I can take an example of a gaming company as well, which has its own set of issues to deal with in the gaming space, and they'll have to take care of this. Similarly, OTT, they have their own problems in the, intellectual property space, the contractual space.
Yeah.
And, they also have to deal with other aspects in terms of the rating of the content, so on and so forth. Now they'll have to deal with this. Plus, I think an important aspect to highlight for the OTT industry is the whole requirement of taking consent from a child's and a disabled person's guardian.
Exactly.
So practically, OTT industry would need to ensure that somehow the KYC checks are done in a manner that they at least can show on paper that they took the consent from the guardian.
Very true.
Yeah.
And yeah, that's pretty contentious. I wouldn't argue anything on that. I think Gaurav makes an interesting comment saying that consent should be in any of the Schedule 8 languages, which is true. But as you clarify, probably the final consent where you press yes should either be in English, should be in English.
It should be. It should be in English because, I mean, that's the language of the law. That's going to be the language also that, the business works in. That's going to be the language of the courts and the tribunals that are going to be set up for this purposes as well. So, yes, I mean, like it happens with most laws in India, especially the central laws. And, also it happens with the senior level courts that English is an official language of, the proceedings. So it is going to be important to have that consent in English as well. And yes, and very honestly, I don't know why this question is about the language of consent, because till now, even if it is a website that operates vernacular content, the privacy policy and the user terms and conditions has always been in English. And there has never been any discussion around the language of the privacy policy or the user terms and conditions. Maybe because nobody thought about, those being important. And now suddenly with this law, your user terms and conditions and your privacy policy become so important. But they always come at the bottom of the website in a small link saying that, the cookie policy, the privacy policy, the terms and conditions, hyperlinks can be referred to. But we've never had this question before. And that shows that how important this law is, because it's actually being discussed in what language the consent should be.
Very true.
Yeah.
So, any other questions? Just reaching out to the audience. Thank you so much for joining us. Any other questions? We'll be happy to take them now.
Yeah.
I think
also, I just want to specify that as far as the consent notice is concerned, the law does specify that the data fiduciary shall give the data principal the option to access the contents of the notice in English or any other language mentioned in the 8th schedule of the Constitution, which is, I think, is what Gaurav was specifying. However, I was just highlighting the practical side of it. That, it says that you need to give the user an option to be able to, get the access to such request in English or another language which is recognized in the 8th schedule. But why I mentioned the practical scenario is that, if English is the language for your business proceedings, courts, tribunals, user terms, privacy policy, then is there, even a scenario where companies would want to ensure keeping just the consent language in a different language? Also, I personally believe that the user terms and conditions and privacy policy would have a lot of cross references and hyperlinks to the consent. Because a lot of companies might want to do that. They would want to keep harping on the fact that we've taken your consent, as given in hyperlink so and so and so and so format, and hence we are doing all of whatever we mentioned in the user terms and condition. And just to ensure consistency, you would again not want that to be in different languages.
Absolutely.
Because you will, create a suit for yourself, having, 2 documents in English and a third one in a different language. where you're cross-referencing?
I don't know too much about the law, but I know two. I'm going to start two startups. One is to translate consent between different languages, and the second, I'm going to start selling data insurance.
Yeah.
Insurance to all companies who get fined 250
Yes. No,
crores
that's a
eventually.
very interesting point. No, it's a
Yeah,
very interesting point. And Krishna, you raised a very valid point as one of the safeguards.
yeah,
I think companies, Indian companies at least, providing insurance policies,
yeah.
in addition to updating themselves on other fronts, should also think about giving data insurances,
Data
because while
insurance.
we do have a data protection insurance in India, which some companies give, the scope is very narrow.
Yeah,
Also the intellectual property insurance. I mean, all of these insurances are, very narrow, because of course, the insurance companies do not earn a lot of revenue out of these insurances as much as their counterparts do in Europe, US, UK, for that matter, Australia. But I genuinely think that data insurance is going to be a space which is going to be looked closely by companies, because with the numbers and the penalties
yeah.
soaring, suddenly this is going to be at the forefront.
250 crores, right? That's the maximum.
250 crores,
Yeah,
yes.
that's crazy. Okay.
Yes, that's crazy, yes.
I think that brings us to the end of this webinar. Thank you, Mehak, for this enlightening session. I hope we can actually have follow-ups where we go actually deep into
Sure.
OTT questions.
Yes.
Also, thank you to all the people who joined. This is being recorded, so
Yes.
we'll produce the video and publish it sometime next week. Hope you can watch it again, share it with all your teams. Again, thank you for joining us on a Friday evening. Hope you have a great weekend. Thank you. Thanks, Mehak.
Thank you, everyone. And it was great to be here. And it was great to have an interactive audience and pose so many questions. Had a great time. So thank you so much. And I definitely agree with you, Krishna. We should have follow-up sessions. And I think as soon as the government keeps coming out with new updates on this, we should keep having update sessions as well, so that we can keep our audience abreast on what is next in store for them. And Gaurav, I think you asked for my LinkedIn ID because you could not find me on LinkedIn. So I will share that. I think I will share that in the meeting group chat also, so that all of you can connect with me. And yes, it's been great having you all. Hope to be in touch.
Thank you. Thanks a lot.
Thank you, everyone. Thank you.
Bye.
Bye.